Yes.
My lords, my lady, slightly unusually, I remain standing at the start just to say this, that Mr Berry, with very becoming modesty, is staying in the row behind us, but I think all council would feel it was slightly more natural if he was to join ourselves and Mr Lemaire in the front row.
Yes.
Permission.
Yes.
We rearrange ourselves.
Great, why not?
When I was in your position, Mr. Berry, I was told the anecdote, the wise silk invites the junior to join the front row, the wise junior declines. Right. Well, can I say, first of all, thank you very much for all the hard work you've put in on this case, and we're very grateful to your efforts. We've got a day and a half. We think we will probably take that. I don't know what you think, what your thoughts are about that. That's our view. So we'd like to know whether you've had a chance to discuss a timetable, roughly, so we can just keep an eye on the clock.
My lord, there was a timetable put into the bundle at the final page of the core bundle where I would be for the morning on the basis that we were starting at 10 o'clock, and then Mr. de la Mare would be for an hour after lunch, and then Ms. Ward would start in the afternoon today, finish tomorrow morning, and then
you get
an hour in reply.
Right. Yes. Well, we think it's possible, Mr. Berry, that you might be a bit longer than that. For this reason, we will want taking through the relevant material carefully, and we think quite slowly. Could I say this? This is we've all independently and collectively come to view this as a difficult question, which the answer is not clear. So I want it absolutely to be understood that we have certainly not made up our minds, or indeed formed anything like a preliminary view. So, but any interventions from the court are not with any preconceived view in our minds, all right? So if you are challenged, and I expect you will be, please don't for one moment think it's coming from any particular angle. We are genuinely undecided and want your help.
Yes, understood.
That applies to everybody. Yes, so where do we start?
Well, my lord, well, this case concern. I was going to take your lordships and my lady through the provisions of EU law, first of all, that provide for the regulation, and then to go through the regulation itself.
We think the regulation will take quite a long time.
Yes. And
starting at the top?
Starting at the
going
top.
all the way through.
Going all the way through the recitals, Title I, Title II, and the relevant provisions of Title III.
Before you do that, could you just confirm that the benefit under United Kingdom legislation, if that is applicable, is payable to the child and not to a parent or other person, that somebody is appointed to take it on behalf of the child, that the benefit is payable to the child? Because I couldn't see a regulation saying that, although I saw a regulation that implied that.
That's correct, my lord.
That is correct.
Yes.
Payable to the child if the legislation is applicable.
Indeed, and the at tab 5 of the authorities bundle, we have the Social Security Claims and Payments Regulation, which provides for a person to be appointed to take receipt of the money on behalf.
It doesn't actually say that payment is to the child.
No.
It's implicit in that.
It's sort of,
I wondered if perhaps it was Regulation 42, which was in the bundle. But we'll assume, and some people tell us afterwards, that it's payable to the child if the UK legislation is applicable.
Yes, and it's so it is a feature that it's not a benefit of the parent, but a benefit of the child.
Yes. Right.
So, my lord, Disability Living Allowance care component, it's a disability benefit for children under the age of 16. The question is whether the respondent was right to remove the appellant's entitlement on the basis the UK is not a competent state. The general issues are whether the appellant can herself maintain an independent right to benefit on the basis of her UK residence, and if not, as regards rights derived from her parents, whether the respondent is correct to say that priority is afforded to the right derived from the father on the basis that he lives and works in Belgium rather than the mother on the basis that she is economically inactive and resides and cares for the...
That's exactly why I asked the first question. What relevance is the mother? Because even if United Kingdom legislation applies, the mother isn't entitled under that legislation to any benefit. So why is there a derivative right from the mother? If the mother has no right, the child has no right. Either the child has the right herself, or it's by virtue of being a member of her father's family. So what's the relevance of the mother even before we...
My Lord's question is good for both parents in my submission, that under UK law, if it's paid to the child, then the mother's theoretical derived right in respect of the mother under Article 21 is an empty shell, because there's nothing in UK law to provide for it under national legislation.
No, that's not my question. There are three sources of right here. One, it is a right, if the United Kingdom legislation is applicable, it's a right that the child has.
Yes.
That's one thing. It's her right. It belongs to her. She has it.
Yes.
The second thing is that there may be a right, and it doesn't matter whether there is or isn't in fact.
Yes.
There may be a right under Belgian law, but because she's a member of the family's father and he's an insured person in Belgium, she may be able to claim via the father in Belgium. But I don't understand at the moment by what legislative route this benefit can be claimed by this child by the mother.
It cannot in the United Kingdom.
Or in Belgium.
Or in Belgium. And
the mother's irrelevant to this situation.
Yeah, my Lord, under UK legislation, the mother, there is no route by which the mother receives the benefit in her own right by reference to the child. But
Mr. de la Mare has prompted me.
I'm reminded that the mother should get carer's allowance, and therefore...
But we're not dealing with carer's allowance,
No.
are we? I thought we were dealing with the care component of disability living allowance.
We are.
So the answer to why does the child have a right to disability living allowance care component through the mother isn't answered by saying, oh, the mother's got a different benefit.
Anyway, as you can see, I did table you.
Indeed.
As you can see, we have.
We have.
So we rather dived in and started panning for gold already. But I think it's going to take us. We better come out of the pool. We better start.
Not at all. I'm grateful, my Lord. It may be helpful if we then start with the provisions of the regulation of the treaty, which govern the proceedings, and the
Tab 8?
tab 9.
9.
My Lord. It's and the provisions on which found the legislative competence to regulate as a matter of secondary law. Tab 9, page 57. My Lords will see in respect of Article 5. The Article 5.3 of that article on page 58 that the Union may take initiatives to ensure coordination of Member States' social security. So the position here is that have primary legislative power to enable a secondary rule to be made. And then if we turn through in respect of the economically active, Article 45 on page 62 of the bundle deals with the general proposition of freedom of movement for workers.
Which page are you on now?
Page 62, my Lord.
Sorry. I just sustained an industrial injury on the paper. Thank you.
And then the power to make regulations in pursuit of that in respect to the economically active arises under Article 48 on page 63, which deals with making the EU legislature, the European Parliament and Council, shall acting in accordance with the ordinary legislative procedure, adopt such measures in the field of social security as are necessary to provide freedom of movement for workers, and so on and so forth. And my Lord will see that that it refers to both the employed and the self-employed.
Just show me again precise to where that is.
Article 48, my lord, on page 63.
Yes, yes.
Yeah. And it doesn't have a numbering, internal numbering at the outset, but the first paragraph. So my lord will see that that deals with both the employed and the self-employed, even though it arises under Chapter 1, which is in respect of workers who ordinarily understood to be the employed.
Is there anything in Article 48, apart from the general power that it creates, that provides any clue to the interpretation of what's to follow?
My lord, no. It's simply that I'm simply showing my lord the source of where the regulations authority comes from. And then for the economically inactive, it's not in the authorities bundle, but the power to make a regulation for coordinating social security for the inactive comes from Article 308 of the EC Treaty, which is now, or did at the time that the regulation was enacted, and that's now Article, on the renumbering of these things, Article 352 of the Treaty on the Function of the European Union. And my lord, I don't think it's necessary, but if it was, we could bring a copy of that.
I think it would be helpful to have it,
So
because that may be the source of power if there's an independent claim by the child.
Yes, I agree. I think it would be helpful to have that, please.
My lord, I do have copies of 308 here to hand out.
Good. I think if we have got 3 copies, I think we'd like it now.
Yes, ma'am.
Agreed?
Yes, it is.
Thank you very much.
Just my page 60 and 61 and 62 and 63 appear to be identical.
My lord, I apologise, I didn't hear the...
My page 60 and 61 are identical to 62 and 63, and I've got nothing about the self-employed as opposed to workers. I've got the same provisions for workers twice. Is that just...
My lord, in the first paragraph of Article 48, although it appears in the...
I got that, but...
Yes, my lord, in respect of the power to legislate for social security coordination, my lord looks at the last line of the first paragraph.
I see that, yes.
They're the same pages.
It's just that we got duplicate pages.
Oh, I apologise.
We're not missing pages, that's my concern. Because I've got 2 pages twice, I'm concerned I should have 2 different pages rather than 2 pages twice, because I wouldn't have expected you to put in 2 pages twice, even if they're important.
I think it's a mistake.
It's a mistake. That's what I wanted to check. Right.
Okay. So we've now got 308.
My lord, yes. And then we can turn to the regulation itself, which is the source of today's controversy. And so we turn to tab 11 of the bundle, and the regulation contains on page 69 it has a preamble and then a long list of recitals. The general structure of the regulation is that it's divided into a number of parts. Article 1 fixes the general provisions.
1 to 6.
Sorry, Title 1. Title 1 fixes the general provisions.
And that is Articles
1 to 10, my lord.
Right. Yep.
Title 2, including Articles 11 to 16, fixes the principles applicable for the determination of the applicable legislation.
How do we know that? I mean, because of the way this is produced, it's got the title at the end rather than the beginning, which it's not produced as if it were in the official journal. So how do we know what the actual title is in
If
page
91. My lord, if my lord turns to page 78, for example, you'll see in the way it's reproduced that the Title 1 appears at the bottom of the page.
So underneath, at the end of each article, is this right?
Yes.
We're told which title the article is in.
Indeed.
I had worked that out. It is rather odd.
It is.
So I've got to know, 91, that's the Title 2 determination of the legislation applicable. That's the definition or the heading of that title.
Indeed, my lord.
And title
General provision.
Title 1 is called General Provisions.
Yeah.
Yes.
Title 2, 11 to 16, you say, is called Determination of the Legislation Applicable.
My lord, yes.
Determination of the legislation applicable.
Yeah.
And then Title 3,
Title 3 is special provisions concerning the various categories of benefits.
okay.
And that's Articles 17 to...
I've got it through to 70.
Okay. Right.
Oh, I'm grateful. And then there are a number of recitals which begin on page 69 of the
Yes.
of the regulation.
And I think we better go through those, or at least those which any one of you thinks is important.
Yes, I was proposing to go through all the ones that have been mentioned on that side of
that would be helpful.
And
no doubt Ms Ward will jump up if she thinks you've missed one out.
indeed.
Okay.
So the first one on page 69 is recital 1, which refers to that the rules for coordination of social security, of national social security systems fall within the framework of free movement of persons and should contribute towards improving their standard of living and conditions of employment. And then recital 2, which is just noting that in respect of the power to legislate for the economically inactive, it comes from Article 308. And then following for persons other than employed persons. And then for recital 3.
This is the predecessor.
No, this is the current. Yes. Recital 3 is referring to the predecessor.
Yes.
In order to since the beginning of the European Economic Community, there's been coordination.
Yes.
Regulations. And
This is the previous regulation.
previous one was 1408/71, and you'll see the final 2 sentences of that in particular. The sentence beginning such factors, and the third line up. Such factors have played their part in making the community coordination rules complex and lengthy, and then replacing while modernising and simplifying these rules is therefore essential to achieve the aim of the free movement of persons. And the reason we mention that at this point is there's a point in ground 3 to do with what is the difference between Article 19 of the previous regulation and Article 21.
Yes, we will come on to that in due
Yes,
course.
yes, exactly. Just putting
Thank you.
a marker down. And then we would turn then to recital 12.
Happy with that, Ms Ward? Missing out 4 to 11? Right. 12.
Recital 12, which deals with the care to be taken to avoid overlapping benefits. In the light of proportionality, care should be taken to ensure that the principle of assimilation of facts or events does not lead to objectively unjustified results or to the overlapping of benefits of the same kind for the same period. I apologise. And also, I've been asked to mention recital 11, my lord. The assimilation of facts or events occurring in a member state can in no way render another member state competent or its legislation applicable. And thereafter, recital 13, that the coordination rules must guarantee that persons moving within the community and their dependents and survivors retain the rights and the advantages acquired and in the course of being acquired. And then, my Lord, recital 15. It is necessary to subject persons moving within the community to the social security scheme of only one single member state in order to avoid overlapping of the applicable provisions of national legislation and the complications which could result therefrom. Then, my Lord, recital 16, which the number for which is at the bottom of page 70, but begins at the top of page 71.
Yes.
Within the community, there is in principle no justification for making social security rights dependent on the place of residence of the person concerned. Nevertheless, in specific cases, in particular, as regards special benefits linked to the economic and social context of the person involved, the place of residence could be taken into account.
And you obviously attach weight to that.
Yes. And then regulation, recital 18A.
Well, don't you want
About
17?
17.
Sorry,
Isn't that partly what this is about, or said to be about?
17, with a view to guaranteeing the equality of treatment of all persons occupied in the territory of a member state as effectively as possible, it is appropriate to determine the legislation applicable as a general rule. That of the member state in which the person concerned, as a general rule, that of the member state in which the person concerned pursues his or her activity as an employed or self-employed person.
That, of course, begs the question of what's meant by the person concerned.
Indeed. It's, my lady, it would appear to be focusing on the person who pursues the activity rather than anyone else. And then recital 18A, the principle of single application applicable legislation is of great importance and should be enhanced. This should not mean, however, that the grant of a benefit alone, in accordance with this regulation, comprising the payment of insurance contributions or insurance coverage for the beneficiary, renders the legislation of the member state whose institution has granted that benefit the applicable legislation for that person. Then, my Lord, recital 20. In the field of sickness, maternity, and equivalent paternity benefits, insured persons, as well as the members of their families living or staying in a member state other than the competent state, should be afforded protection. And the next one I have, my Lord, is recital 24 on page 72. It is necessary to establish specific provisions regulating the non-overlapping of sickness benefits in kind and sickness benefits in cash, which are of the same nature as those which were the subject of the judgments of the Court of Justice, and in the two cases there specified.
And do they include benefit equivalent or similar in nature to the one that we're dealing with? They don't, they're different.
No, man, no. And then...
So you say 24 doesn't apply?
I say it doesn't apply.
German and Austrian benefits.
So does this benefit fall within the phrase sickness benefits in cash?
This is a sickness benefit in cash, but it's not being measured against a sickness benefit in kind.
No, but this is a sickness benefit in
Indeed,
cash, even though it doesn't fall within the two cases referred to. It falls within the words, or is of the nature of a sickness benefit in cash.
And then, because we'll be dealing with various provisions for the overlapping of benefits, recital 35, which is directed towards family benefits, and there's an overlapping rule which we'll come to look at, which is why we cite this provision now. In order to avoid unwarranted overlapping of benefits, there is a need to lay down rules of priority in the case of overlapping of rights to family benefits under the legislation of the competent member state and under the legislation of the member state of residence of the members of the family.
Sorry, which recital is that?
My lady, it's recital 35 on page
thank you.
73.
Are we concerned with the right to family benefit? Not on your case.
My lord, no. But when we come to look at the overall operation of the scheme, there are various specific provisions which deal with overlapping, the omission of which in Article 21 we say has significance. So in some categories of benefit, you see specific provision for rules against overlapping.
Yes.
So it's not a family benefit. The care component of the Disability Living Allowance is not a family benefit within the meaning of Recital 35. Yep.
And then, my lord, finally, recital 45 on page 74.
I'm sorry. Which number again?
Recital 45 on page 74.
Thank you. Any other recitals?
My lord, no. That takes us into Title 1.
Right.
And the first article of which deals Article 1 on page 76, deals with definitions. And I'm not going to go through all of them, I'm going to go through the ones which are applicable.
Yes.
But we start off with a key one, little c, on
Insured person.
Indeed, my lord. In relation to the social security branches covered by Title 3, chapters 1 and 3 means any person satisfying the conditions required under the legislation of the member state competent under Title 2. We attach significance to that phrase, to have the right to benefits, taking into account the provisions of this regulation. And then I, further down the page, member of the family. It's not in dispute in this case that a spouse and minor child fall within the definitions of member of the family. It's quite a complicated provision. If not this, then that, and so forth. But I draw your lordship's and my lady's attention to it on the basis that that's where it crops up.
Just looking at the definition of insured person for a moment.
Yes.
One can't tell whether a person is an insured person until you've worked out which is the competent member state under Title 2. Can one?
My lady, that's correct.
Yeah. So you have to find your competent member state, and then you have to ask whether the legislation gives a right to a particular person, and that person is then the insured person.
My lady.
Right.
And then the next, at top of page 77, little j, residence means a place where a person habitually resides. And at K, stay means temporary residence. It's a distinction drawn.
Yes.
And then at L, my lord, legislation, the definition of legislation, means in respect of each member state, laws, regulations and other statutory provisions, and all other implementing measures relating to the social security branches covered by Article 3.1. Just as a marker, that would include sickness benefits. In Article 3.1, we'll come on to, obviously, to look at that article in a moment. And then I come a series of definitions which all seem to slightly they interlock, but we will come on to look at them. Competent authority at M means in respect of each member state, the minister, ministers, or other equivalent authority responsible for social security schemes throughout or in any part of the member state in question. Okay. Yep. And in this jurisdiction, Great Britain and Northern Ireland have separate social security.
Yes, it's evolved, isn't it?
So they're in different parts. And then institution at P means in respect of each member state, the body or authority responsible for applying all or part of the legislation. And then there's a further definition of competent institution at Q.
Yes.
And it has a number of parts or possibilities, options. The first one, the institution with which the person concerned is insured at the time of the application for benefit. And the second one, the institution from which the person concerned is or would be entitled to benefits if he or she or a member or members of his or her family resided in the member state in which the institution is situated. There's no, in the dispute between the parties, it's not disputed as that there are competent institutions in the UK and in Belgium. Nothing will turn on the various options which are presented under this head of review, this head. And then R, institution of the place of residence and institution of the place of stay. Means respectively the institution which is competent to provide benefits in the place where the person concerned resides and the institution which is competent to provide benefits in the place where the person concerned is staying in accordance with the legislation administered by that institution, or where no such institution exists, the institution designated by the competent authority of the member state concerned.
So the institution which is competent to provide benefits in the place where the person concerned resides, that may be an institution situated in the state where the person concerned resides, or it may be situated in the state where the person is economically active. We don't know from that definition.
We don't know from that.
From that, yes.
Yeah. It's, and then S, competent member state, means the member state in which the competent institution is situated.
Yes, that's potentially confusing terminology because it doesn't necessarily mean the same thing as the member state competent under Title II.
No, my lady, there are a number of, almost an infinite number of ways in which one can assemble these things that have, in terms of the way people live their lives. It has, and then T, period of insurance, which is a term which comes up, means periods of contribution, employment, or self-employment, as defined or recognised as periods of insurance by the legislation under which they were completed or considered as completed, and all periods treated as such, whether they are regarded by the said legislation as equivalent to periods of insurance. Those are all the definitions I have.
Any other definitions anybody wants to draw attention to?
Could we have V, please?
B.
V for Victor.
Optimistic.
Period of residence.
Or vanquished. Period of residence. Period of residence.
All very complicated.
Period of residence.
Period of residence means periods so defined or recognised by the legislation under which they were completed or considered as completed.
That's relevant to the H1
And so that goes to the habitual residence test. And then I'm just reminded by Mr. Rutledge, the VA benefits.
The VA is interesting because that tells us something about benefits in kind as opposed to cash benefits.
That's right.
And they are intended to supply or make available, repay directly or reimburse the cost of medical care and products and services ancillary to that care. So that is something physically provided. to
Indeed.
a person,
It,
which may or may not explain why that's got to be the state of residence, because that's where the person is going to have the medical care and ancillary services.
yes, I mean, one way of, in our jurisdiction, hospital care in the NHS is
Yeah.
benefit in kind. It has. So, my lord, that takes us out of the definition section and into Article 2, which concerns the personal scope of the regulation. And Article 2.1, this regulation shall apply to nationals of a member state, stateless persons and refugees residing in a member state who are or have been subject to the legislation of one or more member states, as well as the members of their families and to their survivors. And then we don't need to look at Article 2.2 because that just deals with survivors. And then
Legislation, we've got to remind ourselves, there's a reference back to laws broadly defined relating to social security.
yes, legislation is defined in Article 1L, my lord, on page 77. And then, my lord, we come on to Article 3, which deals with the material scope of the regulation. And my lords need only look at Article 3.1a. The regulation shall apply to all legislation concerning the following branches of social security, and then little a is sickness benefit. And I'm reminded that each of these heads here correspond to different chapters in Title 3. So there's a link between the if you like, the class of benefit, and then there's each one has their own discrete chapter.
But does a sickness benefit include both cash benefits and benefits in kind? And are they both dealt with in one chapter or within two chapters?
They're both dealt with within the same chapter.
The same chapter, okay.
Okay. I must also to show you Article 3.2, unless otherwise provided for in Annex 11, this regulation should apply to general and special social security schemes, whether contributory or non-contributory, and to schemes relating to the obligations of an employer or ship owner.
Yeah.
And those that embraces special non-contributory benefits.
Which this is a non-contributory benefit, yeah.
This is a non-contributory benefit, but it is not a special one. It's not a special one, my lord.
Oh, I see. It's a general.
So it can be exported. But it's not, if that's not a. So the if to make a sort of give a clear example, the DLA is divided into two different sorts of benefit. The care component is exportable. Is a non-contributory benefit, but it's exportable. The mobility component is a special non-contributory benefit, which means it's not exportable.
Thank you.
And then, my lord, there are various other provisions which are not before us today, but your lordship should be aware of them in Title 1. That there are a number of provisions in the regulation which provide for different sorts of things. Equality of treatment under Article 4. I'm not proposing to go through them sort of article by article because they're not. Article 5, equal treatment of benefits, income, tax or events. Article 6, the aggregation of periods of time spent in different member states. Article 7, providing for the waiving of residence rules. Article 8, dealing with the relations between this regulation.
That might be important. Unless otherwise provided for by this regulation, cash benefits payable under the legislation of one or more member states, or under this regulation, shall not be subject to withdrawal or confiscation.
Same rate, you don't get.
Oh, it just says you can't take it away just because you move away.
That's right.
Yes.
Yeah, okay.
Um,
I just said residence and I left up excitedly, but it's a different problem.
yes.
You can't penalise people.
It's an export.
Yes. My lord will be aware of examples where UK benefits are not uprated.
I can retire to Spain and Cyprus and I can keep them.
Other countries are available.
Wales, obviously, but Cyprus and Spain
Yes.
are hotter
Oh, yes.
and drier.
Hotter in every sense.
Yes. Moving on.
Article 8 deals with relations between this regulation and other coordination in sport. Article 9, the last non-important one that we're turning through, declarations by the member states on the scope of the that takes us to a provision of considerable importance.
Article 10.
Article 10, my lord, yes indeed, which deals with the prevention of overlapping of benefits. And very short, unless otherwise specified, this regulation shall neither confer nor maintain the right to several benefits of the same kind for one and same period of compulsory insurance. And for us, we'll come on to deal with this. It shows you that there can be concurrent entitlements in principle and in practice, and in order to avoid multiple recovery, there is a rule to stop you being the beneficiary of more than one entitlement.
That's the question, or possibly the question, is it a rule to stop multiple recovery, or is it a rule to stop multiple systems of recovery?
Pardon, my lord, I missed.
Is it a rule to stop multiple recovery, or is it a rule to stop multiple systems of recovery? That may be the issue.
Yeah. I mean,
Neither confer nor maintain the right.
Yeah. It's not that if you've got cash from Belgium, you can't get cash from England. It might be you can only get cash from one state or another. That may be one of the issues in the case.
it may be, my lord, but our submission is that it's to prevent double recovery, not looking to more than one state.
It's in relation to the same period of insurance. If you're both insured persons, you'll have different periods of insurance.
So, my lord, if you were seeking a cash sickness benefit for the same period of time, same period of insurance, you couldn't claim a cash benefit from more than one state, for example, by virtue of a concurrent entitlement. But there might be a situation where you're only insured for a certain period in state A, but for an additional period in state B, and that would not be an overlapping in our submission.
But what happens if you've got 50 euros in one, 65 in another? Does it entitle you to choose the 65 or the 50?
The question
So you can't get 115, you can only get maximum 65. Or is it designed to say there's got to be one system? Whether it's 50 or 65, there's got to be one system.
you may be. We say that it prevents if the 50 and the 65 arise in respect of the same period of insurance, you can't claim both. Nor can you claim the difference. You're either insured in one. You can't confer or maintain an overlapping benefit for the same.
If it were one system, then what Mr. Berry has said about you being able to claim in different periods from different places just wouldn't work. Because if you had the right to claim, let's say, both from France and England for period A, but only from France for period B, then if it's to stop overlapping, you could claim from one or the other in the first period and then claim from the one that gives you the benefit in the second. If it's a question of choice of hierarchy, then it's one and one only. It's either France or it's England for the whole period. That must be right.
My lady, yes. What happens is that you may, for example, have the question of where your independent right arises may give you an entitlement in one under the national legislation of country A. You may also derive a right as a family member, and you may have a concurrent entitlement.
Yes.
And that will be from country B. And that situation is allowable under the regulation. That in theory, you could go to country B as a family member or country A, and there might be concurrent entitlements. You might be insured under the legislation effect in the result of more than one state. And you need a rule to stop people benefiting from that over and above.
I understand that. It certainly means you can't get twice the amount of money. I understand that. The question is that all it means, full stop, turn to a new topic? Or does it mean something more than that, which is that where there is the prospect of there being two sources of money, it is not to stop you getting it twice. It is to say there has to be a choice of which one system.
We say not. That's not the way in which that's to be understood.
Right, yeah.
And you rely in particular on what aspects of the way it's drafted? In saying that. The title, provision of overlapping of benefits.
Yes. The title assumes that there are overlapping benefits. There's a problem which needs to be resolved. That we have thus far where we've got to. There's going to be an issue. There will be overlapping benefits.
Maybe.
Or there may be overlapping benefits. And what are we going to do about it? We need to have a rule to remedy the vice. That there's nothing. If nothing else, you cannot confer or maintain the right to more than one benefit of the same type. And say we get it from that.
Yes, and
one and
unless sorry, forgive me.
Sorry, one and the same period is the other point, isn't it?
Well,
yes.
Before we get to that, that's very important, of course. There's unless otherwise specified.
Yes.
Which presumes that there may be circumstances in which there is a right conferred or maintained.
There may be. I mean, this is a rule of general application to deal with if wherever it may occur.
This wording is key because different issues.
And then
it's not the same period.
Yes, I'm reminded that the final phrase there for one and the same period.
well, that's my lady's point, which I think is the key point, or maybe your strongest point on this. One and the same period.
For the same person.
Several benefits of the same kind for
For
one and the same period.
The same person.
And for the same
it's
person.
not
yes.
covering different benefits of the same kind for one and the same period, or several benefits of different kinds for one and the same period, or different benefits of same benefits of the same kind for different periods.
For a different person.
For different persons.
For different.
Can I just do an example? Because I'm much slower. The month of May 2022, AH might have been eligible to £50 by way of care component of disability allowance. Her father has moved on from Belgium and is in a state that I'm not going to tell you the title of, or the name of, but that state too has benefits, and it might be £50, it might be £100, we're not quite sure, we'll check that later. Does this rule or provision simply say if she gets £50 from England and her father in state unknown could get £100, she can get up to another £50 from the other state, but she can't get more than £100 in total? Or is it trying to say you can't have a right from more than one state and you've got to work out in some way or another which state it is?
Yes, the latter. On the basis. Sorry.
No, let's have your submission before my lady asks another question. Well, what's the answer to that submission? What's your submission on that question?
That if she had applied in the UK and had been conferred the benefit for that period in May, there would be no entitlement, regardless of any. This rule against overlapping would prevent her receiving money from state X when it applies to the same period of insurance.
Now, Milena's got a question.
No, I was going to say I agree with that analysis.
There we are.
That's
So
what
if
it,
people
I think that's what it
not
says.
choose claim. Yeah. So it's a choice option. You choose where you're going to choose, but once you've made the claim once, you can't repeat the claim. It's a prohibition on making claims or getting money twice, not a prohibition.
Yeah, conferring or maintaining, exactly. It has, and in respect to the same person and the same period.
Okay.
Well, whether it's choice or not, I mean, I'm not sure it's a matter of choice, but what it doesn't do is help us with the key issue in this case, which is which state is responsible for shelling out the benefit in those circumstances.
Where my lady, yes, where it takes us is that were there to be more than one state from which one could acquire an entitlement.
You can't get it from both.
Exactly.
That's
Exactly.
what it says.
So it helps to make the scheme work because there are concurrent entitlements, for the same period of insurance for the same
So
person.
it prevents double recovery,
Yes.
effectively, but doesn't identify any priority.
No.
That's your case.
Indeed.
Sorry to be difficult. Sorry, it prevents the recovery, but it does not identify priority. But does it require that there be priority?
It says nothing about
Nothing about it.
priority.
It does not identify priority and does not require priority of itself.
Yes.
That there be a priority. So the person can choose. The mother can say, I'd rather take the £50 from England because I'm the appointed person, my daughter needs it now. I'm not going to trust my husband anymore. I'm not going to wait until he puts a claim in state X. And even if he gets the money, he's going to keep it and put it on the 330.
Cheltenham,
But Cheltenham, well, it wouldn't be Cheltenham, it's wherever he's living. That's what you say it is. It's a
Who put it on
simple
Cheltenham?
double recovery linked to the choice or claim made. It doesn't identify a rule of priority and it doesn't require that there be a rule of priority.
My lord, yes.
And you would say the fact that it's called prevention of overlapping benefits shows that it's a long way from
That.
priority,
Yes, and it shows that there may be overlapping benefits in respect to the same
as
person.
we've seen already.
Exactly. Exactly.
Yeah.
And so, my lord, that takes us on to an even more controversial article, Article 11.
Well,
And
11.3e.
yeah, so we're starting the whole of.
You're taking a run up to that.
Yes, cantering up to the jumps. So, Article.
We've done the easy bit, have we, at the moment? Just so I can, we're now moving on to the difficult bit. Right,
This is
okay.
going to get worse.
Just so I can steady myself before we hit it. Right, okay, Article 11 then.
Yes. Article 11 regulates the position to specify the legislation that's going to be applicable.
And we're moving now from Title 1, aren't we?
We are.
We are indeed.
We're
Yeah.
Title 2 now.
Yes.
Just so I remember. So I'm now on to determining the legislation applicable. Yeah,
Indeed, my lord. Yes. And so this is the single member state rule in shorthand. But persons to Article 11.1, persons to whom this regulation applies shall be subject to the legislation of a single member state only. Such legislation shall be determined in accordance with this title, so i.e. Title 2. And the and then you see Article 11.2, which is qualifying provisions in respect to the economically active. But the meat of what we are concerned with is Article 11.3.
Can I just look at 2?
Yes, of course.
Right.
it's doing work within the lives of the economically active and what happens to them afterwards.
Yes. All right. Now use 3.
And then 3, which is subject to other exceptions contained hereafter in the rest of Title 2, subject to Articles 12, 16. So question is which member state, which legislation of which member state are you to be subject to, and it's determined in accordance with the following. A person pursuing an activity as an employed or self-employed person in a member state shall be subject to the legislation of that member state. And then the following C to D are sort of
B to D.
B to D, sorry, are iterations of economic activity.
And they're not relevant here.
They're not relevant.
But they are they're not relevant, but they are all iterations of economic activity, including being unemployed.
My lord, yes.
Under C.
Yes. And receiving unemployment, not just being
Benefits.
unemployed, but receiving unemployment
Yes.
benefits.
That's. I'm sorry. You're right. Yep.
And then E, any other person to whom subparagraphs A to D do not apply shall be subject to the legislation of the member state of residence. And then, key phrase,
Without prejudice to guarantee.
without prejudice to other provisions of this regulation, guaranteeing him or her benefits under the legislation of one or more other member states.
Yes.
And
So at least one party thinks this is the key.
but
The key provision.
Could be.
we would not disagree that this is a critical provision on which this case turns. It has the question of what the without prejudice proviso means in this context. Does it draw in to its definition other provisions from Title III, or does it simply say you determine the single competent state, the legislation, you determine the single member state with whose legislation is applicable for the purposes of deciding individual entitlement, but separately, that's without prejudice to anything else you may derive from.
Hold on a moment. Can that be right? Is the first question I
Yes.
ask myself. Because 11.1 says, person to whom this regulation shall be the subject to the legislation of a single member state. A person can only be subject to one.
Yes.
And then the next set of provisions tell you which one, not which more than one, but which one.
Which one?
And then that makes me think, when they get to 11.3e, are they saying one of the two following things? Despite what we've said above, it can be more than one, and that's what, without prejudice, the other provisions of this regulation mean. So it could be more than one, state of residence and parent state of work. Or is it doing something else and saying, it's got to be one state, it'll be residence when you don't fit into A to D, unless there's something else that says it's not residence.
Yeah.
Do you follow me?
Yes,
It's got to be the latter, hasn't it?
Well, what do you say about that, Mr. Berry?
We say that it is not the latter. It's the former that.
Well, clearly the way 1.3e is drafted, one or more other member states. The word "more" there shows that, doesn't it?
Oh, yeah, one or more.
It's showing the one or more is a pointer to the fact. I mean, in
It
essence,
can be more than one.
it can be more than one. So we're not looking at alighting on option. It's not zero sum between A and B. It's so, and that's a point.
But can we just take the submissions in turn to make sure that we've understood the submissions? Because
Yes.
we're being very unfair to you and dipping in.
No.
But your submission is 11.3e, notwithstanding the opening words of one, contemplates there being a situation of claiming in more than one member state, and that's what without prejudice means. And you say that's reinforced by the fact that it's one or more member states. Is that your...
My submission is that the individual entitlement arises before you get to the proviso, to the without prejudice phrase. And it's determined in accordance with this scheme. What the without prejudice phrase is doing is saying, of course, this is your individual entitlement. You may have as a separate matter, not for the determination of the single state, the legislation of one state. You may have entitlements derived, for example, from being a family member, and you can also get those. You will also still be entitled to seek those as well, but that's not colouring the definition of which single state is applicable.
Well, clearly there are words within the within E itself which support that straightforward interpretation. The first part of the clause, and then after without prejudice, the word guaranteeing.
Yes.
And also one or more other states, member states.
Yes.
But what do you say to my lord's, or was it my lady's point, that does rather conflict with the clear wording of Article 11.1? That I mean, it shall be the subject of the legislation of a single member state only. How does that fit in with this, or doesn't it?
So for each thing that you do, you have to, for each individual person in terms of their individual entitlement, you have to determine the legislation of which member state is going to be applicable to you. But as we will see when we come on to Title 3, you may also derive benefits from being a family member of someone else whose own independent right has been determined under Article 11. So Article 11...
I think I understand. Sorry to interrupt you, but I think I'm just trying to get my head around this. I think I understand the submission to be that this particular part of Article 11 is dealing with individual rights.
Yes.
And there is no conflict between your interpretation of 11.3e and 11.1, you say, because what 11.3e says is that for somebody like AH, they are subject to in terms of their individual rights in their own right, if you like, they're subject to the legislation of their member state of residence. And the proviso is dealing not with individual rights, but with other rights that may arise from other member states, which doesn't derogate from the principle that the primary legislation is that of the member state of residence. Is that the point?
My lady has it, yes. Yeah. And so to give an example, both the child and the father would have, in order to determine which legislation is applicable to them, would each have to go through the Article 11 process in order to determine the applicable legislation of the applicable member state. We know, well, it's uncontroversial, that for the father it's Belgium on 11.3a, and for the child it's the United Kingdom. And having done that, then we know which legislation applies to them. The child then potentially has her own independent right on our argument, and then also an entitlement, if it were applicable, via the father in Belgium. What would happen if she was insured for the same period as the same person? You would go to the overlapping benefits rule in Article 10, and that would resolve the matter. As a matter of practicality, that would resolve it.
So 11.3, first part, tells you which is the competent institution and the competent state for this child.
Yes.
The proviso says, even though this is the bit that's dealing with determination of the applicable legislation for the child, there may be other parts of other titles not dealing with the determination of the legislation applicable, but which will provide an indication that the legislation of another state also applies to the child.
On a derivative basis, because...
Derivative is just a word you're adding. It means nothing.
It may be a difficult word.
Yeah, it's the word. It's describing the state of affairs that the legislation contemplates. It doesn't use the word derivative.
My lord, it doesn't.
It's got to be. That is what I think you've got to say. Is that is what I've just said, which is really what my lady's just said. I think I'm just trying to understand it.
And again, forgive me for being the slowest. Inevitably, I'm the slowest in the room. How do you get around the problem with the clear wording of paragraph 11.1?
The question of individual entitlement is the question. Paragraph 11.1, Article 11.1 deals with the question of individual entitlement. It's not dealing with and everybody. To get into Title 3, everyone has to be defined under Title 3.
So in the first clause, first phrase of 11.3e is consistent with that.
Indeed, man.
And the second, without prejudice bit, is not inconsistent with
It's not inconsistent with it. It's
because it's there. Yes.
It's reminding you, and as my lord indicated, there may be other entitlements. We say that where they are so specified, they refer to derived benefits. But of course, that word itself does not appear in
No,
article.
it doesn't help. It presupposes what you want.
Precisely.
Another way of putting it into English is to say the proviso is opening the door to the applicability of other legislation in addition to the legislation of the competent state.
Yes.
Yeah. Yes. Yes.
Yeah.
And because we know that there can be concurrent entitlements. I mean, imagine a situation where this rule worked exclusively. There's only one single competent state. That's it. You've got to the United Kingdom. That's it. You wouldn't need an overlapping rule if there wasn't something saved. If you weren't getting something from elsewhere as well, you would simply look at the single.
Yeah. Assuming the overlapping rule, Article 10, is, as you say.
Yes, yes. Well, we do say it has to have a job of work to do. It's not surplus, and there is no, and it's because there might be, notwithstanding the fact that you identify a single competent state for the individual entitlement, there are other ways in which you might have. If I just leave it at using that language, there are other ways in which you can get a concurrent entitlement from elsewhere.
Well, Article 10 would have no function to serve unless there are some circumstances in which, under this overall scheme, there are concurrent rights.
Right.
On any view.
Yeah.
Well, I'm just thinking one situation where that would apply. Sorry, I'm just thinking out loud again. And ignore me, it's not helpful. This child lives in Britain with her grandparents. Her father is working very hard in Belgium. Her mother is working very hard in France. Each of those parents, the competent legislation for one is Belgium, the competent legislation for the other is France. That at least must mean two states that come within Article 21. And either you've got to pick between two states, and why, if they're both economically active parents in different countries and grandparents are looking after the child. How then do you solve it otherwise than by the overlapping benefits? To say, well, she can have one, but she can't have both. And you would say this is not a step too far if the grandparents are looking after her here. And if the UK benefit is defined as the benefit of the child, she might have three rather than two. And you would say, so what? That's life. She can't get three, but she could get one from any of the three.
Yes.
And if the parents are not good parents, and they wouldn't be because they're working very hard, the grandmother might be. She might be trotting down to the DWP office every day and getting the relevant money and giving it to the child.
She might well be, and therefore the adult with care would be taking the money and paying it to the benefit, for the child's expenses, and that would be fine. It would be. And there's nothing objectionable. You need Article 10 to cater for my lord's example.
Can we just check in now with how this all fits in with the underlying principle of the freedom of movement? Because that is obviously the running theme throughout this regulation.
Yes, indeed. So initially, of course, freedom of movement extended to the economically active, the workers and the self-employed. And then in the early 1990s, around the time that citizenship of the Union arose, there were directives which then made provision for the economically inactive to have residence rights in other countries on the basis of being self-sufficient or a student and so on. The coordination of social security regulation tracked initially 140871 the economically active and their family members. And so when if you look at Article 1A of the coordination 140871, the principal subject of it is the economically active.
Okay.
The difference here is that the principal subject is the insured person, and then you go through Article 11 as we just saw. And so it's catching up when it comes into effect to deal with the position of the economically inactive around the European Union.
Thank you.
Yes.
Right, so have you said all you want to say on 11.3e?
I have, yes, my lord, yes. It's there's no more else. There's nothing else in that we need to take anything from.
Right.
And then just to note, of course, it's Article 11.3 is subject to Articles 12 to 16, but none of those carve-outs concern us. Exceptions concern us today, except that my lord can see that that there are special provisions in Article 12 for temp posted work, people who are frontier workers, where there's the pursuit of activities in 2 or more member states by the individual concerned.
But that's one person doing 2 countries, not 2 people doing separate countries.
Yes, it's not my Lord's example.
Yeah.
It's a different scenario. And then other provisions relating to voluntary insurance and the contract staff of European institutions. And so...
So the general rule we're concerned with is simply 11, and you say it's 11. Right, so now we go to Title 3.
Now we go to Title 3, my Lord, which... yeah. And so my Lord can see that the title at the bottom of page 99 it begins. Title 3 begins with Article 17, but the provision, and it refers to special provisions concerning the various categories of benefits. It's then further subdivided.
Chapter 1.
Chapter 1.
And that's where we are.
Sickness, maternity, and equivalent paternity benefits. And that's the section which we're inside. And the provision which we are concerned with is, of course, Article 21 on page 20.
Can we just look at 17 en route?
Yes, of course.
We were all stopped at 17.
What's that about when he's at home? So,
As it were. And it should.
My Lord, it concerns the receipt of sickness benefits in kind. So, if we put it health, and it's concerned with, if I put it bluntly, you can receive NHS care and it can be charged to the competent institution in another member state.
and is this linked to Article 32, or is that something separate?
That's something separate.
It's separate.
Right.
So
Yes.
just looking at a practical example, going back to Article 2, let's say we've got somebody falling within 2A. So they're pursuing an activity as an employed person in, let's say, France. Okay. So they're competent member state, or they're subject to the legislation of France because that's where they're working.
Yes.
Right?
Yes, ma'am.
You then, but they happen to live with their family in England and commute across the Channel.
Yes.
So Article 17 says if you fall sick, then you can get sickness benefits in kind in the UK, and so can all the members of your family, as if you were insured here, notwithstanding that the competent member state would be Belgium. France, rather.
My lady has
And it's on behalf of France.
It is indeed.
Yes.
Yes, and so my lords and my lady will be aware that there are NHS charging to overseas visitors
Yes.
regulations, and someone who's a beneficiary of this would not be liable to be charged. It would be because, but the Department of Health could send the bill to the French authorities.
Can I just check the words? In accordance with the provision of the legislation, it applies. If you're working in France and you're living in England, you'll get benefits provided by England
Yes.
In accordance with
the legislation of England.
As though they were
Although-
insured under that legislation.
Yes.
Yes.
Although it's theoretically provided on France to preserve the fiction, presumably that the competent state is France. But if those are better healthcare facilities in England, you'd get better ones.
You would.
And France would have to pay.
Yes.
And
Yes.
France would have to pay.
That's exactly what happens. It has.
But if they were worse than France, say France has a 2-week rehabilitation recovery holiday built into any kind of terrible state hospital in Guadeloupe, you wouldn't get that.
No, you would lose out if you
You'd
went
lose
to
out.
another island. Or, in
But if you
Great Britain.
were working in England and living in France, and France had a better set of things, including the 2-week recuperation in Guadeloupe, you'd get that. But that's because although you're theoretically subject to the state of the competence, the other state's France, the legislation and the content of the benefits is actually decided by the state of residence.
It is.
Yeah.
Yeah.
So that's a clear example of a case where, in terms of hierarchical structure, the competent member state denoted by Article 11 is trumped by the state of residence, in practical terms.
Well, the competent state is still paying.
Yes,
Yes.
that's the point. But they have to pay what the new state, the resident state, if they give you a 5-star
Yes.
hotel with 8 surgeons rather than a
Yes.
hospital with 1 nurse, the bill could be different.
Yes.
My lord, yes, there will be variety. I mean, of course, between the way that sickness benefits in kind are provided, there will be different levels of provision.
But that's an inevitability once you get the structure that's being put in place.
Yeah.
So it lies as it falls. If you happen to live somewhere where you get worse benefits, that's tough luck.
And that's obviously with benefits in kind, isn't it? Because
Yes.
you can't have someone turning up at hospital
Yes.
and then deciding the level of service depends on what the service would be
Yes.
if you were in,
If you're in France.
in your
Or wherever.
Yes, you can have dialysis.
everybody has
and
the same-
transplant. Yeah.
Yes.
That links to
I mean, there are all sorts of
That makes
issues.
perfect sense.
Okay.
Yes, and there's a whole scheme for these sorts of provisions. So if you're staying temporarily outside your competent state, Article 19 applies. If you're residing outside the competent state, it's Article 20 for receiving, say, Article 19 deals with where you're staying, where you've got a country in which you're staying temporarily. And that's the EHIC card scheme.
Yes,
The
that's
E111.
the card that we used to carry.
Yes. And now,
I've now got the replacement one.
Ever optimistic. Yes.
yes.
Okay, so do we need to pause, linger on Article 18, 19, 20?
And 2020 deals with when you travel to receive benefits in kind with prior authorization.
And the same thing applies. It's to use Milady's phrase, it's trumped. Competent member states is trumped by the quality, the nature of the services provided.
The receipt of the service, yes, is not in the competence.
And they're all benefits in kind. So
Yes.
17 to 20, we're talking about benefits in kind.
Indeed, my lord, yes.
So if I go and have my new hip in Hungary,
yeah.
I've got to get the UK to authorise it and they'll pay for it.
Under Article
Yeah,
20,
okay.
yes.
So that's the control mechanism there. I can't go and get
Yes,
gold-plated new hips.
Yes, and if there were to be a 6-month delay, and that would be, then you.
And then I'd have all those court cases about where you can't keep me waiting any longer. I've suffered enough. I'm going to Hungary. But that's the mechanism. It's okay. We pay. We're the state of authorization, but we control it by saying you can't go because we've got a hip around the corner. If you just wait a couple of weeks, and Whips Cross is free on Monday. Yeah. Okay.
Yeah.
But of course, there may be therapy or treatments which aren't provided in one country but are in another.
Yes, and people
That's
see.
true.
Proton B therapy,
Yes.
for example.
Yes.
Tried to
Yes.
some years ago.
All
Anyway,
of those are sideline issues. They don't help us decide this. I don't
well,
think.
I think it helps us. We're getting a flavour. I think we're getting a flavour of what
Flavours
the
of the
regulations like.
structure.
Yes, I mean, it's a way of coordinating rather than harmonising. You might be
Yes.
better off, you
Yeah.
might be worse off.
Yes.
Well, it's what can you get and who pays.
Yes, precisely. And then we get to Article 21.
Okay. Right. Here we have. Here we need to pause. Go through this carefully. Yep.
Yes. So so we start with Article 21.1. And well, in fact, we start and finish with that's what we need. An insured person and members of his or her family residing or staying in a member state other than the competent member state. So that's defined first. Shall be entitled to cash benefits provided by the competent institution in accordance with the legislation it applies. By agreement, and then by agreement between the competent institution and the institution of the place of residence or stay, such benefits may however be provided by the institution of the place of residence or stay at the expense of the competent institution in accordance with the legislation of the competent member state. We don't need to go beyond, we don't need that last couple of sentences. What we are concerned with is an insured person and members of his or her family residing or staying in a member state other than the competent member state shall be entitled to cash benefits provided by the competent institution in accordance with the legislation.
Right. And in our case, the insured person can only be the father because the mother and the daughter are not residing in a state, a member state other than the competent member state for them. So we've got to start off with saying the father is the insured person.
Yes, yes. This applies where you're residing or staying other than in the competent state, my lord. Yes, yes. And so you have to determine. Well, there are a number of questions here, but among them, two very critical ones. Are you residing outside the competent state? And in that context, who is the subject of it? It's the insured person on the article, and members of his or her family. So you have to determine what is the competent state for that person, of the insured person, and the only subject of it, as my lord rightly identifies, is the father in the facts of this case.
Well, that's right, but we've got to be very careful. This is coming back to the terminology that was bothering me in the definitions. Competent member state does not mean necessarily the same thing as the member state competent under Title II. Competent member state means the state where the competent institution is situated, and the competent institution is the institution with which the person concerned is insured at the time of the application for benefit.
It is. But in order to understand which is the applicable legislation, one has to get through
Yes.
Article 11 to get to. I appreciate the reasoning can sometimes seem circular. It has.
Yes.
It's the way it's drafted, but there is a way through it. You cannot get to who is the competent institution without knowing what the applicable legislation.
Well, you can't actually get to who the insured person is
Yes,
without, this is the point I made to you earlier on, without knowing whether they satisfy the conditions required under the legislation of the member state competent under Title II. So you start with Belgium. Belgium tells you if he's an insured person. You then ask yourself, is there an institution with which he is insured? Yes, that will be in Belgium. And therefore, Belgium is the competent member state.
Yes.
That's how you get there.
Yes.
I know it's laborious, but that's how you get there. And then you say, right, well, the only person who this could possibly apply to is Dad, because he is the insured person who is residing in a member state. Sorry. Members of his family are residing in a member state other than the one in which is the competent member state. He's not, but they are.
He has. Sorry, go.
No, my lord.
But I've got another problem now, which must be wrong, and I'm trying to work out why it's wrong, and I think I know. But an insured person and members of his family residing or staying in a member state, does the insured person have to be living in a member state other than the competent member state for this to apply? Does the whole family unit have to live there? Or is it enough if they've separated, so the father is in Belgium and the mother, distraught as she would be, and the child are in England?
That's this case.
Yeah, but which is it then? Because that case is never going to be an Article 21.
Is it the family? In other words, does it have to be the insured person and members of his or her family?
Yeah.
Or is it or?
Because if you look at if you look at recital 20, the comma comes after insured person and says, oh no, it comes after families too. No, it's looking
There
at
isn't a comma.
There is no.
No, in recital 20.
Oh, sorry.
Oh, sorry.
Hang on.
Because Article 21 I thought gave effect to recital 20. But in fact it's insured persons as well as members of their families. And the insured person's got to be living in a member state other than...
Well, that's how I read it.
As well as. So,
Well, my lord, if that's correct, then it doesn't apply in this.
no, it doesn't.
So the child could never have an Article 21 claim in this case and could only have
A claim in her
in her own right under 11.3.
Yes, my lord, yes. If on that construction.
But nobody seems to have said that.
Until
We
you
have
said
There
it.
you are, sent to her.
You've now said it.
But that's why it must be wrong, because somebody would surely have spotted it.
Maybe they have. Maybe they have.
Mr.
other-
Zillemer is saying that he did.
It's paragraph 18 of our submission.
Yeah.
Right, hold on.
Forgive us, Mr. Weber. Let's just roll back for a second. So, what we're putting to you, or postulating, is that
Yes, actually it's there, look. Yeah.
yes. What we're postulating then is that this only applies when the family unit
It's outside of the.
is,
The
in
competent
other words,
member
the
state.
phrase residing or staying in a member state qualifies an insured person and members of his family, not an insured person or members of his family.
Yes, I understand it, my lord's point.
And the phrase as well as in recital 20 might be thought to reinforce that.
Yes,
Might be.
my lord. Yes, we would say we would succeed on either version, but we're not going to. That if that's the correct construction, then there is no application of Article 21 in this case. If it's incorrect for any reason, nonetheless, we come on to our question of whether or not there's any express rule of priority.
Okay.
But before we rush down that route, because that
Doesn't
sounds
feel
fine,
right, does it?
but what about all those other people in the other situation who end up losing out? Because
Yes.
if it was the other way around, if the father's working here and the children were in Belgium, they wouldn't get anything.
They wouldn't get anything from the UK.
And they're not entitled to under 21.
If there was an entitlement in Belgium, or comes from some other, there may not be a sickness cash benefit in Belgium. It might come from family benefits or some other entitlement, but they would be looking to Belgium.
But that runs contrary to the whole of the free movement, encouraging people to go. You do your best. You go to Belgium to work 5 days a week. You come back and live with them for 2 days a week, and they can't claim. That can't be what the regulation is intended, is it?
No, I don't think so.
We haven't put it in our submissions. I understand the construction, and I mean our submission is we would succeed on our case on either basis, and it's so obviously it's a strikeout in a sense of.
But this is important because
Yes.
it would give you the right to the benefit here, but it would have a massively deleterious effect potentially on lots of other families.
On the reverse
On
scenario.
the reverse, and we mustn't just think about the one person
No,
who
no,
get it. We must
indeed.
think about all of those who will lose it.
The scheme.
I just wonder whether 121 must mean we're an insured person and or members of his family, because otherwise it's going to work very harshly. That's why I think I must be wrong. But
Well, there's one. I mean, the function of Article 10 is to scoop up overlapping entitlements and resolve multiple recovery options, and that has to work in the context of the overall scheme. There have to be multiple options in order for that to be entitlements. In order for that to be decent work, we framed our case on the basis that they don't live in the same country. And that.
So do you say that Article 21 does apply or doesn't apply? Just let me get clear. Does it apply where any member of the family is in one country and some members of the family are in the other? Or is your submission that Article 21 is inapplicable to this case at all, notwithstanding whatever consequences there are, because the whole family unit have to be together as a unit?
It hadn't occurred to us, and it's not part of our written submission.
But it is part of Mr. Delamere's.
It is part of Mr. Delamere's, and we say that if that's the right construction, we succeed. Our fallback position, if you like, is that we don't need it to succeed on our.
Well, it may well be. I have an eye to the clock. It may well be that rather than probe that interpretation with you now,
Yes.
we've had some discussion about it. We should wait till Mr. Delamere stands up, and he's going to.
Yes,
Maybe this afternoon he's going to put it
yes.
forward.
We'd be delighted, obviously. If it's,
Yes, but
Yes, the other children.
but others may be less pleased.
so I think obviously Mr. Delamere's now been made aware of what we're concerned about that interpretation.
Yes.
For my part, I'd also like to look at how if there's any clues in the way the whole regulation is structured.
Yes.
To see whether it's permissible to, as it were, ring fence, put it, insured and members of the family in the way which Mr. Delamere is postulating, looking at the language. But
Yes.
let him deal with that.
Yes.
My lord, to save me coming back to it, could I, in fact, ask you also to look at Article 21, 2 to 4, because Mr. Berry said he didn't want you to look at it. Can you?
Okay. Well, let's look at. Thank you.
To extract this basic point, you'll
Shall
see.
we read through it now?
Yes, and I'll just address very briefly what I'm trying to extract from it.
So 2.
2 through to 3 in particular. what in my submission this shows is that the principal focus of the original drafting of this provision was indeed contributory benefits, and the types of cash sickness benefit one is generally faced with is sickness pay paid by the state.
Yes.
And that's why there's the reference to contributions and periods of earnings, etc.
Yeah, but we don't have that.
And the complication in this case lies in the fact that what is effectively was thought to be a special non-contributory benefit has been forced into this chapter.
Yeah.
And that's an important part of understanding how all these rules operate and what Article 21 was originally designed to do.
Well, we'll come back.
I'll come back to
That's
that.
very helpful, Mr. And we'll come back to that
Yeah, I see that.
this afternoon. Right now, Mr. Berry, you're proceeding with your interpretation of 21.
Yeah. So we are. Well, I mean, it's absolutely right, as Mr. Delamere says, that
Yes.
As a non-contributory benefit, the DLA care component wasn't originally designed with this particular article in mind as a result of development in case law that it falls within this provision.
But your case is that this child is entitled under 11(3)(e) or 21.
Yes, and in a sense, and that, well, the scheme allows for concurrent entitlements, and this is an illustration on if the construction that we've just been discussing is wrong and the family can live in separate countries, then this is an illustration of how a derived entitlement may arise that slips within the proviso of Article 11(3)(e) and therefore requires the overlapping benefit rule to protect against double recovery.
Is that because you say that the competent institution in a scenario where the insured person, that is the father, is in Belgium and the family are residing in another member state, that's the UK, the competent institution is still Belgium, is it?
If the fathers are working in Belgium, the competent institution is Belgium.
Yeah, and that has to be right because you talk about the second sentence of 1.1. Talks about agreement between the competent institution and the institution of the place of residence. So it can't be the institution of the place of residence. So you say on that interpretation of Article 21.1 that it is envisaged that a child in a different member state residing may nevertheless be entitled to cash benefits provided by Belgian legislation via father, because he's the insured person. That raises the spectre of an overlap because she is also entitled to benefits in the place of residence. And then the question is, do you resolve the overlap by reference to Article 10 or in some other way? Or does Belgium trump England because of Article 21?
Precisely,
Yeah.
my lady, yes. And we say that if Belgium trumped England, trumped Great Britain, the United Kingdom by Article 21, we wouldn't need Article 10. Article 10 has to be doing something. And so,
Right.
So you say Article 21 is another example, and we looked at Article 20 already. It's another example of something that might fall within the proviso.
yes, indeed, my lady, yes.
Yeah.
Exactly it. And that, and so, and in a sense, you can see what the regulation is doing. It's providing, in the context of where somebody has moved for economic activity, but family members are in across the border in another member state.
Yeah.
It's providing ways in which family life may be efficiently maintained. Sometimes where everyone is happy and as a nuclear family, it may be easy and straightforward, and that the father or the economically active person, whoever he or she may be, applies for the benefit, and there is a relevant benefit. In other situations, in a split family situation like this one, it's different.
And again, going back to freedom of movement, which is the underlying motivation for this regulation.
Yes.
That interpretation would facilitate it.
Yes, indeed.
Freedom. The aim is that freedom of movement should not be impeded by any disadvantageous consequences as far as benefits are concerned.
You shouldn't lose what you've accrued, and you should be able to take it with you. So portability, aggregation, all of these principles, quality of treatment, help in the ordinary lives of working people. You don't want to think, I'm not going to move to take that job because I'm going to be worse off.
My child, who gets good benefits here, is going to be disadvantaged if I go and work in Belgium because the benefits aren't available.
And it would be
I don't want to worry about that. I want to go ahead and move.
Yes, and in this context, we're dealing with a non-contributory benefit, but the scheme is sort of set up for people who are paying social security as a contribution-based system, and you need to have, and of course, it's funded also from taxpayers, as we know. So each legislation in each member state, each state sets its own social security schemes and funds them accordingly. But without coordination of social security, if you couldn't aggregate your pension contributions or have entitlements for family benefits like child benefit or for sickness benefits like PLA, you would be disincentivized to move, and it would impede freedom of movement.
But you do need banks, because the state that you've left or left your children in has a non-contributory benefit. If in fact the benefits you get are tied to the money you're paying to a social security scheme, then it's your choice to go and work in a place. It's only because of the non-contributory element of this benefit.
It would be your choice, but even in a contribution-based system, you would be able to export a cash benefit. You would be able to pay a cash benefit for a sickness benefit for a family member in another member state. So if this benefit, if the father's working in Belgium and the sickness benefit in the UK was a contribution, a sickness benefit was contribution based, or of contributions was deemed to be made, on behalf of someone economically inactive, that wouldn't change the overall functioning of the scheme. In fact, it's designed for that sort of scenario.
Right. Have you said all you want to say on Article 21?
I have, yes.
Right. So now we're going to eventually arrive at Article 32. I think.
We are.
Anywhere
There
in
are
between?
provisions for pensioners. We come on to which are not at the heart of this case, which I wasn't proposing to. When we move through Article 22 onwards, there are special Articles 22 forward are concerned with pensioners, and then up until Articles 22 to 27 deal with pensioners, and then 28 deals with special rules for retired frontier workers as a class of pensioners. And then we move on through further provisions for pensioners until we get to Article 32.
Yes.
And so it's not that I'm trying to avoid them, it's just that I don't think they add anything to what we're...
Well, I don't know. Let's have a look at Article 26. Just to get a general sort of picture of how this operates. I mean, Article 26 envisages a situation in which somebody is receiving a pension under the legislation of a member state, and their family resides in a different member state, right?
Yes.
And it says that the members of the family are entitled to receive benefits in kind from the institution of their place of residence, that's State B, in accordance with the provisions of the legislation, but the costs will be borne by the competent institution responsible for paying the pensioner. Now that seems to me to accord with your interpretation of Article 21.
And Article 20, where we looked at benefits in kind being received by the family members of an economically active person in another country. It's
exactly.
Consistent. Yes.
It's all consistent.
It's consistent. There is. I didn't mean to suggest there was nothing in this. Just simply that there's no innovation. But yes, it's consistent. It has with the.
Yeah. This is again benefits in kind, though.
Yes.
Not cash
Yes.
benefits.
Yes.
That's the problem throughout.
Yes, which is why I didn't focus on it. But it's not a cash benefit rule. But it has a. The trigger is a pension. So in the same way that the trigger for receiving a benefit in kind in the state of residence might be that there's an economically active person in another country. Here it's the pension that makes it.
It's just the different stages of economic activity, work, pension, but for benefits in kind, it's the residence.
Yes, yes, exactly. My lord.
Okay.
Yes.
So now we come on to Article 32. We don't have to worry about 31. Do we?
No.
Or do we?
That's about pensioners.
And this creates a specific sort of rule for allocating and prioritising of the right to benefits in kind. An independent right to benefits in kind based on the legislation of a member state or on this chapter shall take priority over a derivative. And that's where we find the sort of language being used. Right to benefits for members of a family. A derivative right to benefits in kind shall, however, take priority over independent rights, where the independent right in the member state of residence exists directly and solely on the basis of the residence of the person concerned in that state. And so it's creating a sort of express language, which if Article 21 meant what the respondent says it means, you'd expect to find in Article 21 in respect of cash sickness benefits. But you do not find it in Article 21. And therefore, it's so the significance of it is it tells us the sort of language we would be looking for if the respondent were correct. It's not there. It is as it is, Article 21. It is not a conflict rule to resolve competing priorities.
But interestingly, that still says there's got to be one state, and it tells us which it is.
What does it?
Does it?
Well, that's well. If I've just as I've been wrong, I mean, if I've got the wrong stick, leave it on the wrong end. You should let us know.
It's
Shall take priority over. I thought that was meant to mean if you've got the legislation of the state in which you're resident gives you a benefit in kind, but you might otherwise have had a right via a family member to a benefit in kind in another member state. The independent right takes priority from, and I thought that meant that's what you get rather than something else.
Anyone you can assess.
Well, it does, but it doesn't necessarily mean that one state has priority. It simply means that the choice is made for you as to which of the rights you can claim.
Yes, but you can only get it from one state. Only one state is the applicable state, the state whose legislation applies. You can't choose which it is, but there's got to be one state, and this is going to be the state of residence when it's benefits in kind, for obvious reasons to do with the nature of the benefits. But the key point is that a choice has to be made, although it's made for you in Article 32.
You go initially to the independent right, and you ascertain which is the competent, which legislation, which state applies. You work your way through.
Well, could you give some examples of how it works then?
Well,
Now, how does the first sentence?
this, in a sense, is about who pays, because we're dealing with a benefit in kind in the state of residence. So, if you are in you need to understand if you're in
country, if the person concerned resides in member state A, say member state A, and the person from member of the family from whom she derives benefit is in B, then the independent right takes priority unless her rights exist directly and solely on the basis of her residence.
So if we take a spousal situation, for example, and there's a worker in one country, in Belgium, and the spouse in the United Kingdom, the question of who pays and the non-economic spouse in the United Kingdom requires hospital care. The question of who pays for that would be determined on whether or not the person in the UK was or was not economically active.
Well, take a different example. Take a prosthetic limb. That could come from either country. And the person is entitled, it's the husband working in France, wife in England. She wants a prosthetic limb.
Yes.
Does she have a right to a prosthetic limb from England and from France? She might prefer the one from France, might be better, have more things. And is this telling you, no. You have to go and can only go. Priority means you can only go and get the limb in England. You can't get the limb from France.
She is resident in England,
Yeah.
and receiving the treatment for the fitting,
Getting the
for the
prosthetic
procurement
limb.
and fitting of the limb in the NHS. The question as to who pays for it is a question as to whether or not her independent right to benefit as a resident under 11.3e trumps a derivative right. It won't because she's under 11.3e, but if she was working in England, then she would fall under.
No, so she wants to go and get it fitted. She wants the physical product to come from France, because it's better, or she prefers it, and she wants it fitted in France. Or there are innumerable delays in England, or she wants the husband to be there, which could be all sorts of reasons. The first question is, could she stand in a French hospital reception area and say, "Je demande my prosthetic limb," and can she have it? Or will they say, no, back you go, mate. Your limb is in England. That's the first question, not who's paying for the limb, but where can she insist on having it?
But there are different sorts of. My Lord's question breaks down into different parts to some extent, because we looked at a provision for going outside of your country, of member state of residence, to going on a pre-authorization basis to get treatment elsewhere.
Yeah, but this is different because
Yes.
here she's got a husband who's in England, in France, and that's the route. She's not leaving the state and going into Article 20. She's going.
The question arises not so much in the abstract as in the reality. Does she go to an NHS hospital? Does she go to UCLH on Gower Street, or does she go to a hospital in central Paris? And the question there is and if she goes into UCLH, she receives on our system. She receives the help and assistance with the fitting of the limb and a prosthetic limb. At the point she receives the benefit in kind. The question only arises on a who pays the cost basis. It doesn't arise on the basis of should she be compelled to travel to Paris. She's entitled to receive the benefits in kind. And the who pays question is determined by the independent right, the priority of whether it's a derivative right or an independent right. And if it's an independent right, whether it arises on the basis of economic activity or economic inactivity.
So a simple question. My wife lives in France. I live in England. She's working there. I'm not working here. I just want to know the answer. May I please go to France and have a limb in France?
If you can, but you'll be under French legislation and you'll be the spouse of a French worker in France.
Yeah.
You'll be governed by French law.
But I can do that.
You're free to, of course.
And then what does?
But it's not a cross-border situation in that circumstance, because I appreciate you've travelled to France, but
I'm living in England. My wife is in France. We actually haven't spoken to each other for 20 years. Luckily, we haven't got divorced, and I want her leg. Well, I don't want her leg. I want a French artificial leg. And I want to know if I can get a derivative right. And you're rather dodging the question as to whether or not I can claim a leg in France.
Well, you would be.
Or whether Article 32 says, no, you can't have a leg in France. You've got to have it in England. It doesn't matter where your wife lives. Not that England will pay for it.
You're not saying that.
No.
As I understand what you're saying is that. Well, you say it.
Yeah.
But Lord, rather you say it rather than I say it. What do you say in reply to
the if you are seeking this question only arises when you are in a different country to the competent institution.
Yeah.
It has, and in my Lord's example, the economically active wife, you would be present in the country, or you'd be staying in the country in which the economically active spouse is working, and so you would not get in France you would neither be economically active in France, nor would you be economically inactive in France. The question: are you yourself economically active in the UK?
No, I'm a judge. I don't do anything.
If you're you would, if you're economically inactive, you don't have the question of whether you're when you're staying in another country is an Article 17 question. I'm just checking the provision. It's an Article 19 question, my lord. When you're staying outside the competent state, so your competent state for your own individual right would be determined by Article 11. Your right when you're staying outside the competent state would arise.
They're going to send it in the post. I'll fit it myself. You can change the fact. All I want to know is what the purpose of Article 32 is, and then giving you all these examples.
Yes.
Create a situation where I am not economically active and I'm in the state X.
Yes.
Even,
Yes.
and I have a spouse or I'm the family member of somebody in another state. And all I want to know is if the benefits are kind. I appreciate they will normally be provided physically within the state in question.
Yes.
But I just want to know whether what the purpose of 32 is, and that seems to be telling me, but you seem to be telling me that I misunderstood it, and I'm trying to give examples to get to the bottom of it. In a similar question then, what does Article 32 do?
It allocates responsibility for paying for health.
Yeah, I mean, it's very. You said that, as we said 5 minutes ago, but it's quite confusingly worded, isn't it?
It is indeed.
But it talks about priority of rights.
It does.
Not about obligations.
It does. I mean, the difference, of course, is that it's in kind rather than in cash, and the nature of it is this.
So someone living in England wants to have their limb fitted in France. They will be entitled to demand it as a right in if the independent right in the UK derives solely on the basis of residence.
And they get it anyway in the UK. The economically inactive.
Yes, they get it anyway. They always get it wherever you are.
Yes.
You always get it. You're always entitled to demand it.
Yes.
But you can say, no, I don't want the limb here. I want it in France if the derivative right from the father or whatever, if you have that derivative right, and your independent right in England only arises out of residence. Isn't that what it says?
The question of whether you're moving temporarily to receive healthcare benefits, sickness benefits in kind is a different one to whether or not you are
That's the problem.
residing in a place. It's the question. So if you go on a temporary basis, you get a certain sort of healthcare benefit, the EHIC situation, and that's Article 19. If you're resident in a country, and that was Article 20, we looked at, then you can have a.
Okay, so it's not a question of going to France for the operation. It's who pays for the operation in England.
Yes.
Well, then it really is confusingly worded.
It is exceptionally confusing.
I think you can test it without postulating that somebody moves anywhere.
Well,
And you just look at the situation where the family member, let's say it's a spouse, lives in England, has an operation in England, is entitled to the costs of that operation to be paid for as a benefit in kind. As I read it, if that person is married to a man who works in France, then she has a right in her own right to claim the costs on the NHS. She also has potentially the right to ask the French to pay for it as a derivative benefit in kind. What I find very confusing about this is that it seems to me that the second sentence provides that if she's not economically active over here, and her right to claim it from the NHS is purely based on the fact she happens to be living here,
Yes.
then France pays.
That's right. Yes.
But if, on the other hand, she is economically active here, England pays. Is that...
My lady has.
I'm being very simplistic.
No, not at all. That's the answer.
So that's, in other words, 32.2. 32.1 is subject to is subject to 32.2, isn't it?
Yes.
Yeah.
I mean, it doesn't say so. Subject to the provisions of 32.2. It has to be read into 32.1, doesn't it? Because if 32.2 wasn't there,
Oh, yes, actually, 32.2 makes it even more complicated.
Yes.
32.2 is
twists the knife further in another direction. It has it's yes. I mean, inside UCLH there'll be a charging. There'll be an overseas visitors office which decides we've provided the limit. Who's going to pay if they think there's a cross-border issue, because of course it's only chargeable if you're not settled in the UK, and otherwise exempt. If they notice, and this is obviously quite an obscure point, that you have a spouse working in France, then it might be chargeable. That you could send the bill to the French health department.
That just seems bizarre.
If you're working
It's the problem that I've got. If you're working in England, it seems you said to me, you can send the bill to France. If you're not working in England,
But that's why 2 is there.
well,
Because if you're working in England, the buck goes back to England.
oh, what a funny provision.
It's
yes.
absolutely
So-
like a boomerang.
Yeah. And how does this help us though with what we're dealing with?
and-
I thought it might be relevant that this was there and this was a priority rule. It meant you couldn't get it, and then I thought, well, how does that help me deal with the benefit that we deal with? The answer is we don't even know what 32 is doing, let alone how it relates.
I mean, I come back to the point I've made several times that freedom of movement is the underlying principle. I'm just trying to work out
Yes.
how it makes sense. If it makes sense. It makes sense as a way of facilitating freedom of movement or not impeding freedom.
So my lords and my lady will be aware that in the provision of healthcare benefits in kind in Europe, there are 2 sorts of systems. There are insurance-based systems and those which are free at point of use, like the UK and Portugal, on the basis of residence. Portugal, it's a constitutional right. Here we have our NHS Act. And so this rule is directed towards regulating the position where you have a thrust of it is where you have people who are insured.
Yes.
And so those systems, which are in most continental, well, certainly most of the original EU member states in Western Europe, they had when this rule was designed, it caters for that situation in particular because of this question of if you look at 32.2. You notice that in the second line, there's a sort of qualification where the benefit in kind is not subject to the conditions of insurance or activity as an employed or self-employed person. It's catering for situations which are removed from today's situation, and therefore, yes, and so.
So is it, put crudely, is 2 our situation, NHS free at the point of access, and 1 is, in some bizarre way, to do with when you pay an insurance contribution for the medical care?
Yes, I mean, one of the issues which arises under this is that if people are moving and they're not required to pay insurance contributions in one state or another, it may undercut the regulation of the labour market in the host member state, what is to be done here is these rules are protecting, if you like, a number of things. They're allocating responsibility for who picks up the tab, but they're ensuring that people are making their insurance contributions in the country in which they're economically active, and they're ensuring that those insurance contributions are not a tax in the abstract, although it may often look like that. They are to be applied for particular objects of public policy, social security benefits in question, in this case healthcare.
Well, the basic point is that if you are contributing economically in state A, towards getting a benefit, then on the face of it, that's where the money should come, because that's what you're contributing to,
Yes.
rather than from another state to whom you haven't contributed. That's the bottom line.
That is a bottom line, and what this regulation is doing, which its predecessor didn't, was it now has to cater for not just the economically active and their dependents, but for those who are mobile and inactive. And so what you see are bolt-ons, if you like, if I can put it like that, where they are catering for the extra scenarios which are now being embraced within the overall scheme of the regulation.
But you can understand 32.1 in this way then, because of the fact that 2 deals with people who are paying insurance, the independent right to benefits in kind will arise in a situation where that person is working and is paying contributions and is also a family member, and therefore in the first sentence, that independent right to benefits, the one they've paid for, takes precedence. And it makes sense of the second one, the derivative right, takes precedence when the independent right is based on residence only.
Yeah.
Yes.
So it's still tied to the economic activity, but switching from the one person to the other. And then 2 deals with you're not paying for it at all, and then it's residence. So it does actually make logical sense in that way.
Yes.
How it helps us, goodness only.
One other factor is that it's not just about independent right to benefits based on the legislation of a member state, but also on this chapter. So it includes independent rights to benefits based on this chapter. So I'm just wondering,
Contemplates.
that would be, do we look at Article 33 and what else?
Contemplates that the chapter might actually confer rights that national legislation doesn't it?
Indeed,
On the face
yes.
of it.
It's trumping residents' rights.
Yes.
But where this might be relevant, particularly bearing the legislative history, Article 19 for cash benefits and benefits in kind is concerned, this does seem, for benefits in kind, to be saying that the starting point is where you have the benefit because you paid for it. That's the state that should fund the cost.
Indeed.
Where you don't have the benefit
It's residence.
on payment but residence, the state of residence pays the cost. Now that's very profound, but how does it help us?
Well, it tells us this, my lord, that where there is a need to have a rule of priority, it's elaborated with the union legislature has elaborated it with particularity and care, and that's what you see for benefits in kind, and what you do not see that in Article 21.
But what I'm worried about is whether or not implicit in the second sentence of Article 32.1 is this idea that if it's ever a situation of a conflict between derivative rights based on residence, derivative rights and independent rights based on residence only, i.e. the family member is living there but the head of the family is paying, then you tie it to the state of economic activity, not the state of residence.
In a contribution based.
In a contribution based Article 32.1 situation, yes.
Yes, my lord, yes.
In a contribution based, yeah.
And of course, it's only, as I'm reminded, it's only benefits in kind which are being discussed here.
Oh yes.
Yes, yes.
It's I think where we're going is whether or not there's an analogy to be drawn, or whether you don't have to draw an analogy at all. Whether there's some underlying principle that you can derive from this.
Because it will help you in this way. We can deal with this case, if that's right, by analogy, on the basis that the care component of the Disability Living Allowance is itself a non-contributory benefit.
Yeah.
And the conflict between a derivative right and an independent right would be resolved in favour of the independent residence right, not the derivative right.
Yes.
Economically.
Yeah.
Yes.
I'm not trying to help or hinder.
No. But
that would help you, I think.
The parallel is opposite. That if you had to look at the structure of the regulation and the way in which where things are expressly specified, in order to derive the principle to apply in the absence of express reference.
Just give me one moment.
Of course.
So 32.1 contributory So I've written down now contributory benefits in kind. Article 32.1, it's always the economic state, whether it's independent or derivative. Article 32.2, non-contributory benefits in kind, it's the state of residence primarily.
Yes, my lord, yes. And
So I've understood it, have I? For a brief moment.
my lord, yes.
And that's in and that's why
Well, you've written it
say,
down.
Yes, well, I've written it down.
All right. Well, now, just so I've got a marker, how are you doing in terms of where you think you are in your submissions?
Well, I haven't finished the regulation yet.
No, I know.
We have a few overlapping provisions to look at. But when we get to the grounds 1 and 2, I think
We've covered quite a lot of
we've been
already.
most of the way through in reality. Ground 3 is, of course, a short ground about the relevance of the previous regulation. And ground 4 is a very small point. Which
It is. Okay.
Yeah.
All right. Now, anything else on 32?
No, I'm just thinking now, but yes, I haven't got any more questions.
Can we move on from 32? Okay. So, what else is in the regulation?
Just point Article 34, there is express provision on page 119 for the overlapping of long-term care benefits. And really, so there are a series of either rules of priority or against overlapping expressly. Where the point that we seek to make is just that where there is a concern by the union legislature to about overlapping or about creating rules of priority, you see it, and we've seen it already in respect to benefits in kind in Article 32 in that section. And now we see it in terms of the overlapping of long-term care benefits.
I know you want to get on, and I understand your point about they say it expressly when they say it, but I do wonder whether there is something relevant in 34. If a recipient of a long-term care benefit in cash, that's this case, which have to be treated as sickness benefits, that's this case, and are therefore provided by the member state competent for cash benefits under Articles 21 or 29, is that hinting that therefore provided it's got to be? It's saying, sotto voce, we're making the choice for you. If it's a cash benefit, it's got to be through Article 21.
My lord, this isn't a long-term care benefit.
Oh, it's not?
No, my lord, apologies. I was just giving you
right.
an illustration of where we find express provision that has.
Right, okay.
Nevertheless, it does rather seem to suggest, as my lord says, that where one's dealing with a benefit in cash, which has to be treated as a sickness benefit, it has to be provided for by the member state competent under Article 21. There's almost a presupposition of that, isn't there? Regardless of whether it's a long-term benefit or not. It's a cash benefit treated as a sickness benefit, which is therefore to be provided for by the member state competent for cash benefits.
What's being done in this, the job of work being done by this provision, is where you have a cash benefit from one member state for long-term care benefits and a benefit in kind
from another.
From another member state. How do you reconcile the overlapping? Because, of course, you have to put a price on the receipt of the benefit in kind and regulate it. So it's doing a very, very specific task. And it's the cost of care in care homes. It has and it's trying to reconcile what you do in that situation.
But why couldn't it apply? Why couldn't? What's the answer to the point that the phrase "therefore provides" have to be treated as sickness benefits and are therefore provided by the member state competent for cash benefits under Article 21? Doesn't that indicate that is what Article 21 does in respect of cash sickness benefits?
Yes, it's the sickness benefits of which this is one, and then it's saying in parentheses, and don't forget those are provided under Article 21. But it should have said under either Article 11.3 or Article 21.
Well, you're receiving the reason it's under Article 21 is because you're outside of the competent state for the cash benefit and inside the competent state for the benefit in kind.
No. Now, just say that again, would you?
So two states. You're outside of the competent state for the receipt of the cash benefit, but you're inside the state of residence where you're receiving the benefit in kind.
So you might have worked in Germany.
Hold on. So outside the competent state for receipt of the cash benefit.
Yes, my lord, yes. So the long-term care benefit paid in cash, and inside state of residence where you're receiving under that a benefit in kind, the care home provision free.
So that's why they're saying it. They're not saying, don't forget, Article 21 is the source of this. It's simply saying where you've got that factual situation. It's not a defining thing. It's a descriptor of an event.
Yes, where
or
this
state of affairs.
where it arises. Exactly.
Where it arises, yeah, okay. Gosh, this is so straightforward.
I'm not sure about the commas, but there we are.
I'm not sure about this.
All right.
Yes, that's mentioned in the recycling. It is, yeah. And so,
I'm not so sure about the commas either, but
No, the comma. We're worried about the commas.
but he does definitely.
There'll be a comma. There should be a comma after the sickness benefit. Anyway. You're going to draw us. Do I hear a whisper that this is consistent with the recital?
yes, my lord. I'm just trying to find it.
Yeah, it's 2024.
24 I'm grateful. It's which we in the cases of Yark and Molinar.
If I can assist, in a nutshell, this solves a problem that was caused by
Those two cases.
German and Austrian cross-border working, where they have a different treatment for care problems. One state deals with it through a cash benefit, one state deals with it through a benefit in kind. And you've had a gentleman who's been working in Austria but living in Germany, or vice versa. And it was this line of cases in relation to who pays for long-term residential care that the problem is resolving. And
So it doesn't help us with the general.
it doesn't, because as Mr. Berry's explained, the predicate is you're already getting a concurrent right under Article 21, which is causing the friction between two very similar benefits, but one is a cash benefit and the other is a benefit in kind.
The problem is what we're trying to do is find something in the regulation that helps us. So whenever we see the word residence, we fall on it as if it was the Holy Grail. But then it turns out not to be the Holy Grail, it turns to be
All right.
the German version.
Well, there we were, thinking that 32. So you've done with 34. Mr. Berry.
My lord, yes, the only just to note in passing Article 35 on page 120. That's the provision. This is my lord and my lady have it for dealing with reimbursement between institutions. This is how a bit of the functioning of the regulation, and then there are other rules to prevent overlapping. Just to touch on them briefly, in Articles 53 to 55.
Yes, we were wondering whether you were going to mention 55.
Yeah. This relates to preventing overlapping of different classes of benefits, invalidity, old age, and survivors' benefits.
That doesn't affect us.
No. And the reason I mention it simply is just that, again, it's an example where there is a concern by the legislature to make provision. You see it elaborated carefully. And then the...
54 is more likely to be helpful.
Sorry, my lady, I didn't...
I said 54 is more likely to be helpful, isn't it? Because 54, on the face of it, appears to cover a situation where you might have a direct right to a benefit in cash under State A and a derivative right through parent to a cash benefit under State B. You've got to have benefits of the same kind.
Yes. You're under the legislation of 2 or member states of that.
You say that's not this case because there isn't a right to a benefit in Belgium.
Yes. But this obviously is within the provisions for old age and survivors' pensions. Is the target.
Isn't this a different problem? This is just pro rata. You're entitled to a couple of years' pension from Germany and a couple of years from France. and the overlapping doesn't stop in you getting pro rata amount from each. That's what this is about.
Yeah.
It's not our problem.
Precisely, yes. My lord has it has a
Yes.
What about 55?
55 is so the benefits in this situation are of different.
Okay, so that doesn't apply here.
No, they're of different kinds. They're just purely within.
So they don't apply.
Yeah, they don't apply.
Well, they.
And then final priority overlapping rule is Article 68 on the page 139 in the context of overlapping family benefits to cater for the situation where there are multiple entitlements arising and how to prioritise. And so we see there that where during the same period and for the same family members, benefits are provided for under the legislation of more than one are provided for under the of more than one member state. The following rules of priority shall apply. And then you'll see in little a the way in which it works that in the case of benefits payable by more than one member state on different bases, the order of priority should be as follows. Firstly, rights available on the basis of an activity as an employed or self-employed person. Secondly, rights available on the basis of receipt of a pension. And finally, rights obtained on the basis of residence. So there is a hierarchy. There is a priority list, and it's obviously dealing with the different ways in which entitlements can arise in Title 3.
All right.
So, my lord, those are
Any other questions
on the regulation.
Thank you.
So, my lord, I don't know.
Well, where do we go? You're now going to your grounds, are you?
Yes. Well, I was going to just tie a few threads together if we haven't already covered them and go through the regulation and as part of going through the grounds, but I don't know whether it's convenient now or whether 1 o'clock would be more.
Well, I think if you don't mind, we'll carry on for 10 more minutes.
Yes, of course. So our looking at the scheme as a whole, our primary submission is that as a matter of ordinary or purposive construction, our interpretation of the regulation is to be preferred. We don't need fundamental rights to get us home, but as it happens, they may buttress our position. But we say on a purposive construction of the regulation that the independent right based on residence can be maintained, and the UK is therefore the competent state. We say that serendipitously that happens to be consistent with fundamental rights. It facilitates support, and in terms of the effectiveness, because this is obviously dealing with real people leading real lives, it deals with support for a child in a split family situation. And so the objective of if a sickness benefit is to be paid for a disabled child, then that's achieved in this situation. My lords and my lady already have the general thrust that there may be multiple concurrent entitlements arising from different sources to a particular class of benefit, such as sickness benefit, and that where these concurrent or multiple possibilities arise, there are a number of ways in which the overlapping is resolved. We've looked at Article 11, which does the initial job of work of determining the single competent state. We've looked at priority rules, such as Article 32, which creates a hierarchy where there are different sorts of entitlements coming from different places as regards benefits in kind. And where concurrent entitlements nonetheless subsist, Article 10 is a safeguard because it prevents overlapping. So there's a whole series of provisions in the regulation. It's our case, of course, that we have the independent entitlement and that the tribunal was wrong to give the priority to the to any entitlement derived from the father. That's the error of the tribunal's approach. Article 21, properly construed, is simply not a rule of priority. It doesn't colour, not only does it not contain any of the words that we've seen where rules of priority exist, one can't be implied into the way that it works. One can see that, for example, very clearly, because it doesn't. If there was we discussed an example where there were parents working in two separate member states, other than my Lord Justice Lewis raised the example of an example where there's a parent working in one member state A, another parent in member state B, and the child is resident in member state C. What would you do? You turn to Article 21. If you look for a rule of priority there, you won't find one as between the derived entitlements from mother and father, if those are the parents it has. And so you can see that not only in our case, on the facts of this particular case, but in other factual scenarios, it wouldn't work. You can't read into it what isn't there. It's as a matter of fact, in this case, of course, there's only one claim that's made for a sickness benefit. It's made by the child in this country, and the child has an independent right under the scheme that's been struck by Parliament has been that it is the child who receives the benefit, which is unusual in benefits legislation in this country, that the child is the actual target of it, albeit that the payments are administered by an appropriate person on her behalf. So, put very briefly and briskly, there's simply no barrier to the independent claim made in this case. If you look at all the component parts of the regulations that we've looked at in Title I, the general provisions, including the overlapping rule in Article 10, Title II for determining the single competent state, and Title III, the provision made for particular classes of benefits. The whole thing has to work as a whole. Each thing has to do its own job of work. And on the Secretary of State's construction, there's no real role for Article 10. And that can't be right. There has to be something there to be done. The way in which the scheme operates is that in respect of the child of a family where a member of the family has moved under the freedom of movement provisions that allow a person to move and work in another member state, the scheme for the coordination of social security has to be flexible enough to allow the family to live their lives in a meaningful way. And this is that merely because the child may have under the regulation, leaving aside whatever provision is made in national law in any particular member state, the child may have an independent right in this jurisdiction. It may be that in other cases, involving other countries other than the United Kingdom, a sickness benefit may accrue to a parent. And you need to have the flexibility in the regulation to allow for entitlements arising in different ways for categories of benefits. This regulation has to work, not only self-evidently across, as the UK was inside it at the time, 28 member states of the Union. It has to work because each of them will have struck their choices in different ways, and the number of permutations which come up is almost infinite variety of possibilities, where each choice is being made in each member state. And so that rule does the job of catering for that the child's entitlement may arise in a number of different ways, and different families will be leading different lives.
Yes.
Yeah. And so...
Well, is that a suitable place to stop, Mr. Berry? How much longer do you think you're going to be?
I could probably about 20 minutes.
Well, that seems to be, despite our interruptions.
Yes. No, I don't know.
We're thank you for your tolerance.
No.
And will you tell us after lunch whether growing four is something we need to trouble ourselves with, given we've got quite enough to worry about?
I will, my lord. Yes.
My Lord, if it's helpful, we've got copies of the regulation in the consolidated version, and it's a lot clearer to read than the PDFs.
Yes, definitely.
We can provide that. What we can also provide, I've told Miss Ward we're intending to rely upon it, is the domestic regulations that introduce section 72, 7B.
Yes. Well, perhaps we could have all that at 2 o'clock.
Yeah.
Thank
Very
you.
well.